Okay, let's try to get this working correctly. Welcome, folks. Welcome to today's Law of Self-Defense show. Once again, we have a fantastic guest with us, friend of Law of Self-Defense, Steve Gosling. Steve, how you doing?
Hello, can you hear me?
I sure can.
Awesome.
Steve was able to join us on very short notice, which I'm always
very short notice.
Well, happen. So we're here today to talk about the news that the Bodega worker in New York City, the charges against him have been dropped, the murder charges. You'll recall he was charged that night, the night of the event, with second-degree murder, which is my recollection from New York state laws. That's the highest degree of murder applied in New York state as a practical level. I believe they still have first degree on the books, but it's capital murder, and New York state does not do capital murder. So second murder is the highest you can hit somebody with. That's what they hit him with, and $250,000 bail, which was then reduced to $50,000, which he made. But if New York follows the traditional bail practice, that means he had to come up with 10% of that as a bail bondsman fee, $5,000 that he does not get back, folks. That's the fee to the bail bondsman for putting up the money. So Jose Alba, the bodega worker, is out $5,000 and a couple weeks of peaceful living. Not to mention, of course, having been subject to that attack in his store. So we covered this case in some detail shortly after it happened with the video of the event. I'm not going to show the video in this show because when I showed it in the last show, YouTube was kind enough to label the video as being adult-only content with a big warning on the screen. And of course, that also induces them to not share the content generally on the platform, which is not very helpful to our mission to getting this kind of information out to a broad audience. So if you'd like to see the video,
I know a lot of the chatters want to talk about it and consider updating, because I know when you did that, I actually watched. I was not a guest on the second time we did it, but there was a lot of forthcoming stuff. There was other video angles. And I know there was also audio.
Audio was released, right? Which I didn't have when I have.
So we didn't have that. So you're going to have some new stuff to talk about on that with the updated information, which I would imagine that the state attorney's office had prior to making the decision, right?
Right, of course.
Yeah,
they would have had everything right from the start. So it's important when we look at these kinds of cases, because one of the big dangers I see is actually hold on one second. Let me see if I can grab something here.
Bunny. Evil bunny. I love the chat room in the Law of Self-Defense chat room. I'm a frequent lurker too, so I watch y'all's chats.
All right, folks, nothing but the highest production value here at Law of Self-Defense. The thing I wanted to grab was the most current issue of American Rifleman magazine, which I get as an NRA life benefactor, whatever super high level they conned me into paying for. And in every NRA magazine, whether you get American Rifleman, American Hunter, First Freedom, or however many magazines they have these days, there's a section in here called The Armed Citizen. And The Armed Citizen is a series of little vignettes, little paragraphs about prospectively law-abiding people who use guns in self-defense. And invariably, these narratives work out great for the people described. The bad guy is run off or killed. The person who used the gun in purported defense of self or family or property is never arrested. They're never charged. They're never convicted. They're never sentenced. These are all feel-good stories. But I can assure you, if you know the law of self-defense, the actual law of self-defense, you'll read many of these vignettes and realize these people were not arrested, charged, convicted, and sentenced, not because they couldn't have been, many of them. They could have been, but they got a lucky break. Discretion was used in their favor. And in the law of self-defense community, we don't conduct ourselves in a way that we're reliant on the good graces of some politically appointed prosecutor. We don't want to be in a position to win only if we get the benefit of that guy's doubt. We want to be in a position to win on the legal merits. So it's very dangerous to learn self-defense law, learn it in scare quotes, from these kind of anecdotal instances, because you may believe that this is the inevitable outcome that had to have happened. And that's certainly not the case. It's not the case here. Now, I'm very pleased with this outcome, as any of us would be, I think. But when I say I'm pleased about it, I'm really talking about one of really 3 levels of analysis or understanding you have to have about these use of force cases. And the first is the feeling level, how you'd like it to turn out in a gut sense, what feels like the appropriate outcome. And certainly on that level, this feels like the appropriate outcome. This guy was minding his own business, the bodega worker, at his place of employment, not bothering anybody, got accosted by a crazy lady who brought her boyfriend into it, who was quite aggressive physically, the initial aggressor in that confrontation. It feels like a, don't start none, don't get none kind of
that
situation.
might be called has jury appeal is what we might call it, right? Even
Right.
if you don't have all the elements of law on your side, something has jury appeal. That's what we say it, right?
And we have the same feeling when, some father finds a boy in his daughter's bedroom in the middle of the night, things along those lines, right? There's a natural sense of outrage in those cases.
Mhm.
But how we feel about a case is not at all determinative of what the law may actually hold in that particular case. To understand that, you have to know the actual law of self-defense, which of course we teach here at Law of Self-Defense. I don't have my little flashy card, the 5
my
elements
book,
of self-defense and all that stuff. I've got the book here. For those who'd like the book, by the way, you can get the book for free at lawofselfdefense.com/free book. Anytime you want, you get one free copy. We had somebody try to get a couple hundred free copies. That doesn't work, folks. Just 1 free copy per person. But you can get it at lawofselfdefense.com/free book. And when we look at the law, of course, we're doing a technical legal analysis. We're not predicting what the outcome will be, or at least I never do that. You've never heard me predict a verdict in the case because there's too many variables and there's too much noise in the system. What we can do is look at the arguments on either side, which is what a good lawyer should be able to do all the time, and try to evaluate the merits or the quality of the arguments on either side, and also the vulnerabilities of the arguments on either side. Now, this is not a case where there was zero vulnerability on the part of the bodega owner. He did go to deadly force under circumstances where a reasonable person, not everybody, maybe not most people, maybe none of us watching this right now, but a reasonable person might have decided, well, he wasn't obviously, explicitly, unambiguously facing a deadly force threat. It's not like the person he killed had a gun, had a knife, had a bat, had a deadly weapon in his hand. Now, you don't have to have those things to be a deadly force threat. It could still be a lawful use of a knife by Jose Alba, but it's much more ambiguous than would have been the case had Simon, the quote-unquote victim here in legal terminology, the victim of Alba's use of force, had he been armed with a deadly weapon. Then it would have been essentially incontrovertible that Alba was facing a deadly force threat.
Right. Well, I've been thinking about this case a lot. One of the reasons I emailed you is because I have been thinking about this case a lot, and maybe it's from a defense attorney perspective, but the thing that really strikes me as a defense attorney defending the bodega owner is that the girl left with a threat. I'm going to go get my boyfriend.
Right.
She comes back. Now, the boyfriend could have come back and paid the $3. But he doesn't come back and pay the $3. He instead comes back with force. And I think that, you could say that was an attempted robbery of some sort. I think that there was that, and I understand we're going to look at it. One of the interesting things, you have layers, because you have the law, which is kind of an abstraction. And then you have facts that come in that have to be fit into the abstraction. And so as I thought about it, I really thought that the attempted robbery aspect of it was very relevant to this analysis. But I'm jumping ahead, I know, because I know you're going to get the 5 points. But I have been thinking about this case quite a bit since we talked about it last. And
yes,
really
the biggest changes for me, additional evidence that came out since I did the first analysis of this was one, the actual audio of the girlfriend making the threat. Now, there had been reports of her making a threat, but I've seen in many of these cases, there's claims of all kinds of things that ultimately are not supported by the evidence. So until I see evidence, I take all those kinds of claims with a very large supply of salt indeed. But
Sure.
here, the audio was finally released. We could hear the girlfriend making the threat at least twice that she's going to get her boyfriend Simon to come back and F this guy up. And as far as I'm concerned, you're threatened with getting F'd up. That's serious bodily injury. That is a deadly force threat.
They come back in furtherance of that threat. You're anticipating it. He then acts. He's going around the counter and physically assaults him.
Right.
Which is a burglary, right? I mean, if you have well, let me think about that.
Yeah, it would. He didn't unlawfully enter, which is
true.
what New York State would require for a burglary. And I'm not sure we have evidence of a robbery because he didn't demand the item without and say, with no apparent intent to pay. He was.
Right.
I think he was just pissed that he perceived his girlfriend or the girlfriend's daughter had been disrespected by the.
But the perception is measured from the perception of the bodega owner. So
yeah, but it has to be reasonable. So what's the basis for a robbery?
Well, that's where that jury appeal comes in, because I think if you can formulate an articulable, reasonable fear, then the jury, you can buy into it. But of course, but if you're arguing, you're losing, right?
Yeah, ultimately, I think he doesn't need it because we have enough cumulative evidence here, especially stuff that emerged later in a demonstrative way, that we don't need the robbery because there is more than enough to have a reasonable fear of serious bodily injury, at least at the hands of Simon. One is the girlfriend's threat. So everything that follows now is in that context. Words alone are never enough to constitute a threat against which you can use defensive force. But that means words literally alone. So the threat all by itself would not have been enough. But what words can do is almost be enough. And then the amount of physical conduct, the overt physical act or conduct that you need to see to create a reasonably perceived perception of deadly force harm, that physical act can be very minimal. It doesn't have to be much. Someone threatens you with a knife or a gun, and then they reach for their waistband as if for a weapon. That could be sufficient, even though the reaching motion by itself is very modest. Here we have not just the verbal threat by the girlfriend, but then Simon actually shows up, acting in an aggressive manner, and in fact is the initial physical aggressor in this confrontation. Another key piece of evidence here for me, which I would have liked to have seen developed more, but just superficially would be enough. When we get that opposite view angle, it looks like not only did Simon use one hand to grab the back of Alba's shirt, but he moved his other hand around to the front of Alba's neck, which becomes easily perceived as a deadly force attack. Now your hands are effectively around someone's neck. That's not really grabbing someone's shirt. That's not really shoving them against the wall. This is a threat now readily capable of causing serious bodily injury. And you control someone's neck and head, and you control their whole body.
And there's a clear physical disparity, size, age, right. And that does factor into the self-defense argument, because when you see him sitting, I mean, he's a full head shorter. He's 25 years older, and a young man of 25 or whatever, in mid 20s against an old guy like me, we're definitely outmatched.
So when we look at kind of the merits of the legal analysis, it's clearly overwhelmingly favorable to Alba. Maybe not perfect. I mean, it would have been more perfect if Simon had some kind of weapon, but pretty darn good, especially in the context of the state having the burden to disprove self-defense beyond any reasonable doubt.
Do they have a stand your ground law, though, in New York?
Nothing like in the Florida sense. So they do have a castle doctrine for your home, but I believe it only applies to dwellings. It wouldn't apply to a place of business in New York State. New York State's a pretty aggressive duty to retreat state. Mm-hmm. But it wouldn't matter here because there was no real safe opportunity of retreat. He tried to retreat, arguably. And even in states that are aggressive about pursuing a legal duty to retreat, it's only required if it's practically possible and can be done in complete safety, which otherwise the duty doesn't apply.
Shane corrected me and said that the stabby was 37. So I stand corrected. But still, even still, a 25-year difference.
Yep. It's a big deal for sure. Listen, I'm 57. I know I don't bounce like I used to, for sure. No. So that's the legal analysis. And I think it's overwhelmingly favors Alba here. Folks, that does not mean that Alba can't be prosecuted, because then we get to the third level of analysis, which is the political level. And the fact is, the reality is the prosecutors have essentially unlimited discretion on who they want to drag into court. We have this theoretical probable cause threshold that's supposed to be met, or a grand jury threshold that's supposed to be met. In my professional and personal opinion, it's bullshit. It doesn't really exist. If the prosecutor tells a half-ass reasonable story to the judge, you're going to be going to trial. And it doesn't really matter what the legal merits of the case are. The judge will say, well, we'll decide that at trial. A trial that could cost you hundreds of thousands of dollars, where there's never zero risk of getting convicted. No matter how innocent you are, there's at least a 10% chance you're getting acquitted. And that's if there are not aggravating political circumstances in the case. Now, imagine this wasn't a minority Jose Alba bodega worker, but a white male or a white police officer who had killed Simon. You don't think the politics would be different in New York City? Of course they would. You don't think that might drive a prosecution despite the lack of legal merits? I mean, I only have to point you to the George Zimmerman trial, or the Curtis Reeves trial, or the Kyle Rittenhouse trial. These are all cases, especially Zimmerman and Rittenhouse, where there was essentially zero evidence inconsistent with self-defense. And the Curtis Reeves popcorn movie theater trial, the fact pattern was very similar to this. You had a much younger, larger, stronger male physically aggressing on a much older man under very confusing, poorly lit, abrupt circumstances, where you have to make instantaneous decisions under incredible stress, readily perceived as being a deadly force attack. All those people went to trial, despite their legal defenses being overwhelmingly favorable.
Especially the Rittenhouse and Zimmerman cases, the popcorn trial. Remember, I sat through some of that torture, but that was a much closer case than this one. I think this Bodega case is a lot clearer. But what your point you're making that people do not understand is that the prosecutor is very important, and you have, and there's two levels of this, because you have elected prosecutors who will give a lot of deference to their trial division. So, let's take it out of the political context. If you have, and some prosecutors are very hands-on and don't let their prosecutors drop anything without approval, and they're very constrained with what they let their trial level prosecutors do. And when you get politics involved, it almost always goes up to the elected or the chief prosecutor, and then it gets all these political considerations, which is absurd, but that is the nature of the beast. I mean, I'm not sure how to take the politics out of it, because you're going to have human beings functioning in this government, and so there will be politics. But yeah, it's sad that that's true. That's why I'm for multiple checks, like a stand your ground hearing. Then you have a dismissal motions. You have appellate review, which is useless in some jurisdictions. But get the more shots at getting a dismissal, the more protected the citizen is. But then it sort of narrows. So you start out with strong case. And then okay, well, then the prosecutor prosecutes, and then it gets to the judge, and then it gets to the jury, and you go through and output. At some point, that person you hope is guilty, but there are innocent people convicted, and politics is one of those reasons that innocent people get convicted.
Yeah. So if this prosecutor wanted to bring this case to trial, it would be going to trial, regardless of the legal merits and regardless about how any of us watching this show right now feel about the particular case. And clearly, he initially did, right? I mean, he brought second-degree murder charges for a reason. His office demanded $250,000 bail for a reason. He was pursuing this case very aggressively, and then the politics turned against him, and he made the politically prudent decision. Don't assume from this that if you find yourself in similar circumstances in his jurisdiction, that he's going to decide in the same way. This decision by him is not controlling on any other prosecutor in any other jurisdiction for sure, and it's not even controlling on him. If he got the identical case next week, he could make a completely different decision on whether or not to go to trial. So I'm always very cautious about, concerned, I should say, because I feel like people hear about these events and these legal conclusions, in this case, that the charges are being dropped, and they decide, they learn, quote unquote, they learn from that, hey, under these circumstances, that's what happens. The charges get dropped. Well, maybe, but maybe not, folks. It's not up to you.
Somebody commented also, and it's a great point, and it's right on it. Thank God there's surveillance video. And we always come out, and I guess we're reviewing when you go on these things and you look, usually you're reviewing video, right?
Right.
A lot
If
of
I
our
can,
cases
yeah.
don't have videos.
Right.
And in those cases, all of a sudden, your eyewitnesses, who's the girlfriend, who's in part of her response, she might be culpable. So it's her interest to make it look as bad for the bodega owner as possible. So the video, I think, has been a very good thing for criminal law, because it's a lot of our sheriff's agencies here now wear body cams, and they were very resistant when I first came in. When they first started coming in, they were sort of resistant to that, because they thought that we tricky defense attorneys would come up with all kinds of loopholes. But actually, I found about 95% of the time it helps the prosecution, and it at least adds clarity to the case and the issues in the case. I can't think of a body cam video that has really been destructive to the case, other than helping the parties work out what the proper way is to go. And ultimately, and sometimes it does reveal police misconduct, but those are pretty small relative to its tire. So I'm just saying the presence of video here is really important for the politics of it.
Yeah, I mean, I'm a big fan. It's, in my experience, if you have a genuinely law-abiding use of force in self-defense, especially if the person bothered to learn where the legal boundaries were in the first place, that person, hopefully every member of the law of self-defense community, you want video, my friend. You want video. Our cases tend to get in trouble not because there's too much evidence in the case. They tend to get into trouble because there's too little evidence in the case. And then our narrative of self-defense begins to look ambiguous or is contested by other evidence, like that would be the girlfriend statements here. That's not going to be favorable to Jose Alba, right? What she has to say in the absence of a video. So I'm a big fan. In fact, there was a famous part in the George Zimmerman case where the police were interviewing Zimmerman immediately that night. I believe it was that night after the shooting of Trayvon Martin. And they were trying to trip him up, his story of self-defense. So they came back into the interview room and they did what police are allowed to do. They lied to him about what evidence they had. And they said, George, we got a real problem with your story of self-defense. And he says, what is it? And they said, well, we found a surveillance camera that captured the whole thing on video.
Right. I remember this.
And Zimmerman's response to that was, thank God.
Yes, I remember that.
Right.
Now that's an interesting memory. That's right. I do remember that.
So especially if you know what you're doing, if you've read the book, folks, and you're actually keeping yourself within the legal boundaries, that video, you want that video. You want more evidence. That doesn't mean chatter to the cops in the immediate aftermath of the event, but you want that video. I mean, I can tell you, at my house, we got a lot of video cameras here, because God forbid anything were to happen here, I want everything captured on video for sure.
Right, and if you're a good actor, and the object of these kind of things, and somebody was asking a couple chats ago, I forget, I'm a lurker, right? But was asking about about why are you studying this? What's the purpose of studying, say, a law of self-defense book, or going to a course, or doing whatever? And that is to get the right frame of mind, so that you are, when you deal with a situation and a fact confronts you, that you have the right mindset. And you don't have to be a defense lawyer or a criminal defense lawyer, but you do have to be educated enough and responsible enough so that you have a firearm, especially carrying a firearm outside your home. And one of the points that you'd made a couple chats ago, which is worth repeating, is that when you're in I think that having a firearm in the home, that is dependent on your cool-headed nature and recognizing yourself and looking at yourself, assessing yourself to see whether or not you're responsible enough and you're cool-headed enough not to shoot a family member when you're angry, not to do something crazy. If so, then the defense of home is a very good situation to use it. Once you take that firearm into the public or use a deadly weapon in public,
it all becomes much more ambiguous,
much more complicated. That's where you need to get educated, especially, although education never hurts anyway, even if you're in the home. But don't drag the body back in the house. That's you ever heard that bit of advice?
Yeah. So I talk about it every class. I talk about it.
Yeah.
Class of consciousness of guilt evidence.
Right.
So I see Will Parker commenting as Freddie Merck. He's one of our moderators too. He's a great self-defense instructor up in Montana. Will, I'm still trying to figure out if I can schedule time to ride up and ride around Glacier National Park with you before the cold hits. Maybe. I'm working on it. But he makes a comment here saying this is a great example of having non-deadly force options. So you don't have to, because arguably that might have worked here. And interestingly enough, I don't know how many people saw this, but in fact, Jose Alba had a non-deadly force option. This is the confrontation right here. Here's Simon on the left. Here's Jose Alba here. It's just starting. He hasn't even been shoved yet. Up here in the upper right-hand corner, folks, that is pepper spray. That is the same brand of pepper spray I carry. It's just a different color. So it's not hard for me to recognize. It's right there on the shelf. And, you can't help but wonder. And believe me, I've worked this job, folks. I've worked convenience store jobs. And you sit behind that damn counter many hours. And it doesn't take very long before you know everything that's behind that counter because there's nothing else for you to look at. There's nobody who would ever convince me Jose Alba did not know that pepper spray was there. Now, does it mean under the stress of the attack that he has to go to that? No, not necessarily. I mean, we don't react the same way under stress we do normally. It would be forgivable, even reasonable for him to forget it was there under the circumstances, especially if he thought retreat was the smarter option, and that's what he was trying. But nevertheless, it was there. So technically speaking, he had a non-deadly defensive force option available to him within hand's reach if he had decided to go that way.
That's pretty good catch. Where did you
I just happened to see it when I watched the video.
Good eye. Yeah, it's amazing. I found that you get into these cases and you watch them over and over and over. And after a while, you get so familiar with all the details, and then they jump out at you and it's hard to unsee it. And so that's sometimes hard for you to get through to a jury because they don't see the things that you have when you've watched the video 300 times.
Sure.
When I prosecuted the Joey Calco, who was the Joey Milano, he was the Bonomo crime family hitman who was in Palm Coast, Florida, and he hit somebody in the head in his pizzeria, and he was in the witness protection program. I don't know if you remember that case. Okay. And anyway, it was the world's dumbest criminals, and there was a surveillance video of this gun. And it was very important. I watched that thing so many times. And after a while, you start seeing these little details. And it's amazing the things that are in these videos that can help you if you are on the right side of the law, which is where you want to be, right?
Right.
Yeah.
Or unfortunately hurt you if you're on the wrong side of the law. So that's not where we want you to be. I
would say fortunately too, because I want good people to be protected and I want the bad people to be put away. That's
unfortunately, what happens in my world is often people have been well-intentioned, normally law-abiding people have been badly misinformed about what the law allows them to do in terms of use of force. So they think they're acting lawfully. They genuinely have that subjective belief. In fact, one of the most common things I hear in cases I consult on is the client saying, I can't believe I'm getting prosecuted for self-defense, because in their head, it was self-defense. If you put them on a lie detector and asked them, they would say it was self-defense and they would pass that lie detector test. They just misunderstand what self-defense means from a legal perspective. And they don't understand that they've stepped over the legal boundary because they had no idea where the legal boundary was. And them stepping over it was completely inadvertent. But the legal system doesn't care what you think the boundaries for self-defense are, folks. It only cares what the boundaries actually are. And if you step over them, then you're outside the bounds of lawful self-defense. And what you did was simply a crime. Unless you get very lucky and get a very sympathetic prosecutor. And then you're getting a break. And we don't like to rely on breaks.
I don't usually equate sympathy with prosecutors.
No.
Those people are, it's a head-chopping world on that side of the aisle.
They're in it to win it.
They're very unforgiving, I would say, as a matter of practice, based on their job. They're used to dealing with same thing with judges. That people don't realize that judges see people coming for them, endless strings, thousands of people pleading guilty, and so to them, everybody that's in front of them is guilty.
Right.
So when you say not guilty, you're like, okay, I've heard that 1,000 times before. You just haven't pledged yet. And so there's this almost a predisposition that everybody should be pleading guilty if they're in the court. And the judges, it's sort of a callousness that gets developed over time. And I think as human beings, we need to lean against it. But it is, after you see, well, 1,000 other people have said not guilty, then they change their mind. Why are you saying you're innocent?
Yeah, and it's even worse with cases of self-defense, because every bad actor who actually acted unlawfully in using force claims self-defense. It's just a legal defense. Their defense lawyer is going to throw up and make the state disprove beyond a reasonable doubt to meet their burden. That's what your defense counsel is supposed to do if they can make that argument with anything resembling a straight face. But it means there are a lot of facially bad, weak self-defense claims made in court. Judges see it all the time. Prosecutors see it all the time. And so they just presume that if someone's claiming self-defense, well, it's just like the 10,000 other times they heard it. This is just a nonsense claim of self-defense. They don't see that many good guy claims of self-defense come through the system. So they're always very skeptical.
And it's also the close cases that really get hammered, because especially the minimum mandatories, we have a lot of minimum mandatories and statutes in Florida. And what happens is somebody comes and they've got a close case. And you feel like it's triable, but if you lose, you're going away for life. So the people's like, well, wait a second, I am acting in self-defense, and that's a good argument. And you're like, yes, you've got a good argument, but I put it like even a good defense case is 50-50. I wouldn't even put 10%. I'd say it's 50-50, because it's hard, because what do you do with those people? Yeah. And the hardest cases, of course, the ones that are actually innocent and the prosecutor thinks they're guilty, because there's only one good outcome then. And people want to roll those dice, but then losing a case where the person's actually innocent, boy, I've had that happen once.
That's
the hardest thing of all.
Hey, Uncivil Law, another attorney in this loose YouTube group of attorneys we have, Steve. Uncivil Law, Kurt is in the comments. Kurt, if you want to come on board, let me know and I'll send you an invite. I don't know if you have time. Kurt's a very active legal YouTuber himself.
Now the decedent here, my understanding is that he is a multiple convicted felon. Is that correct?
I believe so. Of course, Alba would not have known that, probably.
Well, I don't know. He was pretty balanced. Did you hear some of the audio?
I did, but we don't know if Alba knew that.
Right.
Just because someone's threatening doesn't mean that that they're a serially convicted felon. Here, I sent you the link. If you want to join us, feel free. If you can't, that's fine too. But I sent it in your as a Twitter message or whatever that's called.
He had one of the funniest statements to the person when she declined. He was actually quite polite to her, and it was a $3 decline. Yep. And then he says, well, I'll try it again. And he tries it again. It fails again. Then she starts yelling at him. He says, well, why don't you get a job? That's pretty funny. Yeah.
Yeah. So, and of course, if Alba knew that Simon was a multiple convicted felon, especially for violent crimes, that would have gone to his subjective state of mind. That would have made that knowledge admissible in court, and the jury would have heard of it. But generally speaking, it's very often the case the victim here I mean Alba, the bodega worker, doesn't know the criminal history of the person attacking them, and therefore could not have played a role in their subjective perception of the threat, and therefore it's not admissible to the jury.
Well, it depends. And this is another reason you don't talk to the police, because one of the questions they'll ask you is, did you know this guy? And if you lock yourself down, and, the thing is, you might. Memory is a very difficult thing. And people don't understand this. Like eyewitness IDs are big problems, because people's memory, they will say for sure it happened this way.
Yeah.
And it for sure did not happen that way, especially the video shows you this. But no, I remember it, because our memories are not like video cameras. Our memories are not snapshots, and especially under stress. So the fact that he says, well, I don't know this guy, but then you say, oh, you know what? That was the guy that did this, or maybe he did, but then your memory changes and adapts. So give your attorney maximum ability by keeping your mouth shut with the cops, because they'll exclude that. Have you ever met this guy before? No.
Yeah.
Boom.
It's it's very common for people to we just assume that we're going to have a clear recollection of what happened. But folks, I've taught hundreds and hundreds of in-person law self-defense full-day classes, and for many of them, at the end of the class, we would set up a shooting simulator, a very $20,000 piece of equipment. where you're shown, the students shown a video of a prospective aggressor, and they have a little infrared toy gun that they use or not use to defend themselves. Their task is to solve the problem, whatever the video threat presents, how they think appropriate. And then when they're done solving the problem, they have to explain to the class what they saw, what they did, and why they did it, their legal rationale for that use of force. And folks, this is a completely harmless environment. We're in a classroom. The lights are dimmed a little bit, but there's a big projector going. There's no real threat. It's a video image that they're facing. You can't possibly get hurt unless you trip over your own feet. But the stress these people obviously visibly experienced in going through this simulator was palpable. Their voices would shake afterwards. Their hands were shaking. We had one student accidentally drop the fake magazine out of the pistol, pick it up, and shove it back into the gun so hard, backwards he shoved it in, so hard that we needed tools to get it out afterwards. And he had no recollection of having done that, whatever. And of course, the whole class watched him do it. So these students, they couldn't remember what they did. Or if they did remember, they couldn't remember the sequence or the timing properly. And of course, if you can't remember what you did, you can't really explain why you did it. Now, in their minds, they had a subjective image of what they did, but it was very often completely disparate from what the rest of us observing them saw actually happen. Another reason not to give any kind of detailed explanation to the police in the immediate aftermath of a use of force event, just like, by the way, the police themselves don't do, are not required to do in the immediate aftermath of their own use of force against a suspect.
Right. Well, and if you're interested, I have a friend of mine who I co-authored a paper with, the AI face matching paper, Dr. Brian Cutler, who is a brilliant professor, and he would be an interesting interview talking about memory and false memories and how it's created.
I would love that.
Yeah, he's an interesting fellow, and he has, and I've learned so much. I mean, basically everything I know is really from Dr. Cutler, and he's got multiple books on that and how people will construct memories, because what happens is there's so many different phenomenons here, but one of them is people will construct memories from a sequence of events. So you'll observe one event and you'll observe a second event, and they may be unrelated, but our mind seeks coherence. We want to project structure onto what we're seeing, and we want to understand because, evolutionary wise, it makes sense. Oh, the guy was drinking water by here and he's eaten by the alligator. Don't go next to it because so your mind is made to make these kind of connections, right? And you'll make connections even when they are unconnected. And then what happens is you actually remember that connection. I remember it vividly. I saw him shoot and I saw. When you didn't see any of that, you constructed the memory based on trying to rationalize what happened. It's a hard phenomenon for juries to understand that eyewitness testimony is very unreliable.
I've seen it hundreds of times. We would run students through the simulator I was just talking about. And then when they were done, we'd have them turn their back to the screen. And I'd ask them, first thing, all right, tell us what you saw. How many aggressors? What did they look like? What were they wearing? What color was his hat? And there was no hat. I made up the hat. But if I asked them about a hat, they'd come up with a color. In their mind, they would think, oh my God, there was a hat. It must have been some color. Oh yeah, it was blue, even though it never existed in the actual video.
Well, another one we have is police lineups. That's another where it comes in, because what they'll do is they will show you a picture of the person, and then they show you the lineup, and you're like, oh, I recognize this guy, but you recognize him from the picture you just saw, not from the incident. But you're like, oh, and your brain all says, well, that must be him because he's the only one I recognize. So contamination of eyewitness lineup IDs is a big problem in criminal law, because, and there's some rules that have been added to them, but it's still not perfect, because a lot of this contamination with memory, it can cause false IDs and false convictions. And it's not an insignificant problem. Now, obviously, there's a lot of people that, there's a lot of guilty people out there. But we're just saying this is why you want to be careful when dealing with the police and dealing with any kind of situation where you're interacting with the cops, because you don't know what kind of landmines are out there. And if you're out there spilling your guts, you think, everything will work out because I'm a good guy. All of a sudden memories change and they've created, oh yeah, that was the guy right there. And you don't know what's behind that. And all of a sudden you're facing life in prison. Yep. So it's too dangerous to not be educated.
Hey, Kurt's here in the background. Let me bring Kurt up. And Kurt, you can meet Steve if you guys haven't met before. Hey, Kurt, welcome aboard.
Hey, Kurt.
Hello.
Great.
I remember Kurt.
I feel honored. Thank you.
Of
Yeah,
course.
It's good to be here.
the
It's nice to
bank
be
you
with you.
did
It's been a
bankruptcy
while.
law, federal stuff, right? Or patent law, was it?
Well, patent law was my day job. I just recently walked away from it after 15 years, but yeah, trying different things.
That's enough patent law for anybody.
Mm.
15 years of patent law. Boy, that was so. What did you do to deserve that fate?
Mm.
Anyway,
had
for
a computer
those
science
looking at
degree.
this Bodega case from the emotional perspective, like you see this video and you imagine, hey, there's no way anyone could view this other than Simon being the bad actor here and Jose Alba being the good actor here. They'd have to be crazy to see it otherwise. Well, for one thing, we have the benefit of the video. But I
Thank
can
God for
assure
that.
you, even when there are cases where any reasonable person you would think could only have one view of what happened, you can still end up with a highly politically energized case. And we're seeing that happen right now with this case out of Minneapolis, where we have this guy, Tekle Sundberg, who fired AR rounds into an apartment with a woman and her child were inside and ended up getting killed by the police. Let me pull up this screen share here. Let's see. This guy, this nice gentleman here, apparently he was just firing rounds into her apartment. By all appearances, we have the rounds, the hits in the apartment. They're at body level, folks. I mean, it almost looks like he was tracking someone across the room. They're not just in the ceiling or in the floor. They're where you would expect them to be if he was trying to hit human beings with that rifle fire. And of course, getting struck by an AR round is an excellent way of ending up dead. As you can tell here, perhaps not the most upstanding citizen in the world by the own images he posts up on social media. Yet, despite this, Benjamin Crump is out in full force, ginning up support and political energy in favor of this guy. It's hard to believe, but he's already has his own GoFundMe going. For some reason, GoFundMe is okay with this guy, but here's Benjamin Crump's tweet. This is Tekle Sundberg. Minneapolis Police Department killed this smart, loving, and artistic 20-year-old after an hours-long standoff while he was experiencing a mental health crisis. We need answers from MPD as to why his mental health crisis became a death sentence.
Ooh, I know the answer to this one.
Yeah, how about that?
I know the answer to this one. I can help. I already know. It's not hard. Yeah.
So Benjamin Crump makes his fortune off of these kinds of cases without ever going to court. I'm not aware of him ever going to court. He gins up political energy, especially racial energy, around these kinds of cases, sufficient to compel the politicians who control the purse strings to spend other people's money to make their political problems go away. And that money goes right into Benjamin Crump's pocket. And every time he does this, he gets another 20, 25 million, $30 million settlement. And he's pocketing a third of that, folks. That's a pretty efficient way to accumulate capital.
I've changed my mind, man. I want to be Ben Crump. Maybe this is the worst travesty of justice ever.
Listen, I'll be the first person to say, if I have a client that would get the support of Benjamin Crump that I was defending, I want Benjamin Crump on my side too. He's good at what he does. But it's very easy to have political, racial energy built up around a case, regardless of the utter lack of legal merit in support of this case. And of course, Crump is involved in many of these cases dating all the way back to Zimmerman, and he's become a lot more sophisticated in his practices since the Zimmerman days, for sure.
Well, one thing that there's a good lesson here, though, that's outside of the politics of it, which is something is that whenever somebody dies, they become an angel, right? So whatever your victim of a shooting, and you act in self-defense, all the good stuff that they ever were is what they are, and that's the prosecutor's going to take that side, and there's limits to what you can do as a defense attorney to tear down. Oh, you're disrespecting the victim and, you're tearing down. It's hard to paint somebody like that, especially when you have a mama up there testifying on behalf of her son, who everything is wonderful and he's the greatest kid. And you don't want to attack mom because mom didn't do it.
Right. I mean, especially in states like Minnesota, where this most recent shooting happened, where they have what's the phrase they use for it? Not proof of life, but testimony of life, something along those lines, where you're explicitly permitted to bring in all the family members to talk about how much they love this guy and how awesome he was and how loving he was. And of course, the defendant doesn't have anybody like that speaking for him. But because
you can't get
right. So because the victim died, the law allows for that kind of highly emotional testimony, frankly, in my opinion, grossly inappropriate testimony, because we haven't yet determined guilt. I mean, if guilt had been determined and we were talking about sentencing, then you have victim statements and so forth, talk about the damage they've suffered. But to have this kind of testimony allowed before we've even had guilt, to me, is purely an emotional play, which should have no role in the guilt finding phase.
And another lesson here is that you shoot in a defensive role to stop the threat. You don't shoot to kill. And that's sort of a question, people say, well, it's better that the guy died. No, it's better to stop the threat. That's the purpose of the self-defense shot, not to, put a bullet in his head to punish him for being the bad guy. You're in my house and I'm going to kill you. That's not what you do. You shoot until the threat is down, and then you're cautious and you make sure that person is safe and disarmed, or you can retreat to a place until the police get there and control the situation. You don't shoot to kill somebody. I mean, you don't want to have that on your conscience. You don't want to do it unless absolutely necessary.
And it's generally in your best interest the person doesn't die. I mean, if they die, now you're looking at a murder or manslaughter charge. If they don't die, you're looking at an aggravated battery charge, which is no fun, but it's not life in prison without possibility of early release should the worst happen at trial.
Interesting.
So I'm going to start going through super chats, I think. But before I do want to mention the sponsor of today's content. I have to do the sponsorship thing, which is no less than law self-defense itself, folks. If you'd like to have a seat at a free, 100% free webinar where you're taught how to be hard to convict if you ever have to defend yourself against criminal predation, your life, your family, your property, this would be the way to go. 100% free. It's about a 2-hour webinar. It doesn't cost a penny, but you do have to sign up because seats are limited for each one. And you can do that. Sign up at hardtoconvict.com. We have several of these. We run just about every week. Just pick whichever date is most convenient for you, date and time. And there you go. hardtoconvict.com. All right. So let's see if we have anything in the super chats.
Another angle, just throwing out another issue, just one more little point that and this is what I've been thinking about this case a lot since we last talked, and that is the liability of the female in all of this, because to me, she might, there's some liability there under the felony murder rule, and initiating this, and I haven't, obviously, I doubt that this prosecutor is going to charge her.
No, in fact, I believe they announced they weren't going to quite some time ago, actually.
Well, there's two separate things we're considering here, right? One is whether she might have felony murder liability for what Simon did.
Mm-hmm.
The second is whether she might have legal liability for what she did, her stabbing of Alba. Those are two different things.
Well, she's got a good defense of others for her stabbing, I would think.
I certainly a straight-faced defense, right? She can argue that, hey, I believed that whatever Simon did, it was not sufficient to justify the deadly force response from Alba. That belief need only be reasonable on her part. It doesn't have to be correct. And if she had a reasonable belief that Alba was over-responding outside legal boundaries, going disproportional by going to the knife, even if she's wrong, if she had that reasonable perception, she could very well be privileged to use deadly defensive force in defense of Simon against Alba's use of the knife. Again, she doesn't have to be making a correct decision here. She just has to be making a reasonable decision here. And depending on what facts she claims to have known, that could be a hard position to overcome when you have to disprove it beyond a reasonable doubt.
And I will say that the law, I mean, this is politically incorrect, but we are on the politically incorrect channel, is that the ladies usually get the better deal. I mean, I've just found that it's the general course of conduct when the prosecutor is looking to turn a witness, it's always the female, even if she's an instigator, because she gets the men to do her bidding. And I think that's kind of what happened in this case. And so they usually get, what is it? What did the mafia did in the mafia? Although that doesn't really exist. But theoretically, they would say they don't want the women involved because they would be turning. The prosecutors would threaten them and they turn. And
Yeah.
I'd see that in case after case after case.
Mostly the guys do that too.
Yeah.
This notion that the guys never don't rat each other out is.
But and especially if the good looking women too, boy, that's hard to convict. Talk about hard to convict. Be a good looking woman.
Yeah, well, we just saw a flavor of that in the Amber Heard Johnny Depp trial.
Well, there's
I thought it was pretty absurd, though, that when the prosecutor in New York was charging the guy for his self-defense, but not charging the woman. Because I'm like, if you're gonna, it seemed like these presumptions were just completely off. I understand that these are political realities, but it just seems so bizarre to me as from a legal reality that you'd reach these conclusions so fast.
It was a fast charge too. I mean, do you have
Yeah.
any thoughts on that, Andrew?
I just think on a superficial view for this, this is a Soros type prosecutor. He's of the Benjamin Crump kind of cut of cloth. He sees a relatively young black man stabbed to death when he's unarmed in a dispute. He says, "Oh, I can make political grift out of that." And so the charging. Remember, he can always pull back the charge. It doesn't cost him anything. He didn't lose $5,000 in bail money by making these decisions. He didn't lose anything. So all of this cost him nothing, but it could have said if the facts had turned out differently or the politics had turned out differently, he could have been one of these, just like the Angela Corey in the Zimmerman case or the Binger in the Rittenhouse case. These are people who are looking to make themselves famous, to win political capital, to win re-election.
It's
whatever
so wrong, though. That is
capital is.
You and I understand that's the way it is, but it rubs me so wrong because, I mean, that is such a betrayal of all the ethical prescriptions that are given to prosecutors and their role in the system. The prosecutor is supposed to be an advocate for truth. They're supposed to be an advocate for the citizens, and that includes the accused, and to protect the accused rights. And the judge is supposed to be a fair and impartial thing. And the defense attorney is supposed to be an advocate for their client. The system does not break down on the defense attorneys being too strong advocates for their clients. The system breaks down when you get these prosecutors who are making decisions wrongly and judges who do not play the fair game, but play one side, usually the state. That's usually where the system falls down. And I hope that people see that because, and this is a good example. I mean, this one worked out. Thank God that this guy's getting the case dropped. But boy, if the media wasn't on it, he might, probably wouldn't have.
And thank God there's video for it, because if there wasn't video, there's no way this case gets dropped.
Right.
Which is
then it would be what? It would be Alba's testimony against the girlfriend's testimony.
And he's going to jail. He's getting convicted in New York. Good luck, I mean, come on.
Especially, you have to keep in mind too. I mean, if you don't live in a place like New York or have never lived there or any kind of dense urban center, it's hard to imagine how hated these kind of convenience store bodega places are. Most of the normal supermarkets have been run out of the community. Mm-hmm. And so the only place to buy a lot of commonly needed goods are in these convenience stores and bodegas, and they charge a premium because of the risks they run and the constant shoplifting that's happening and the hassles they have to deal with and the difficulty in getting employees and what they have to pay those employees and the rent they have to pay. But to the consumer coming in, a pack of cigarettes is $15. They feel like they're getting ripped off. Mm. And so they often, there's a hatred in the community that these people, and often the people running the convenience store or the bodega are of a different ethnic group than many of the customers coming in. So you have that. It engenders racial animus as well. But who's the jury going to be made of? Not bodega
all the
workers.
Time. I don't know this. This is interesting because I'm not a New Yorker. You're from New York, right?
Yep.
Yeah. See, I don't know that aspect of the bodega culture. We have Publix in Florida. That's great.
Publix is good. They make good sandwiches.
Yeah. Well, you don't have too many Publix in Manhattan.
No.
So that's part of the problem. All right, let me step through some of these super chats. Evil Bunny, a frequent commenter. Thank you, Evil Bunny. Frequently offers me technical advice and expertise I have yet to take advantage of, but I promise to do that as soon as I can get around to it. Thank you very much. $10 super chat. Zenothium15, $5 super chat asks, what's more dangerous, dating Amber Heard or Borowski's daughter? Okay.
Who's Borowski's daughter?
Borowski was a judge in the Theodore Edgecombe homicide trial. He was a very hard-nosed, no patience for any kind of nonsense type of judge, was constantly castigating both state and defense about any slipshod practices they tried to get into his courtroom.
Yeah,
he would just shout people down,
Agreeableness is overrated,
Oh, he was a very, very disagreeable judge. A very good judge. I mean, I really liked the way he ran his courtroom personally. But anytime especially the defense tried to get wishy-washy in his courtroom, he just shut it down. He was famous for maybe giving one warning, and then it was Chambers, in my chambers right now. And
great.
Very good. I liked him a lot. He kept order. I much prefer that to a wishy-washy judge that loses control of the courtroom to the
Well,
lawyers.
remember, the popcorn shooter judge was kind of all over the place.
Yep. We see a lot of that, frankly, and they're trying to be too agreeable. Unfortunately, I mean, it's going to sound sexist, but often it's the female judges, I think. Females, women generally are more agreeable than men by nature, for obvious biological reasons. And but it's hard, if listen, I'm a defense lawyer. If I think I can get away with stuff in your courtroom for my client, I'm going to do that every day of the week and twice on Sundays.
But so is the prosecutor.
Right. So
And
you
that's
get
the problem.
chaos.
They should not. And that's the thing, that a prosecutor should be disciplined enough to know that cheating in the courtroom deprives a citizen of their rights, and that's to fair trial. They don't, if you can win as a prosecutor, I was prosecuted 6 years. If you can win as a prosecutor without cheating, you should do it. And if you can't win without cheating, you should do it anyway, right? I mean, it's like it goes, they should not cheat as a matter of power, but it becomes the self-interest win guilt rather than justice and fairness.
And we see it all the time. I mean, in our community, law self-defense community, just these trials we cover, in the Rittenhouse trial, the lawyers are blatantly misstating the law about what's required before deadly force can be used in self-defense. In the Zimmerman trial, they did this thing where they had downloaded all the contents off of Trayvon Martin's cell phone, which required a special machine to do that, to capture all the deleted stuff as well. And they burned it onto a DVD, and then they prepared a written report, kind of a summary table of contents of what was on the DVD. And they handed this to the defense, but they deleted from the written report some of the items that were on the DVD. So the defense, they just looked at the written report and they're like, all right, well, we don't need to watch 15 hours of DVD content. We can see from the written report, there's nothing interesting here.
Wow.
But there was interesting stuff. And when it was discovered, when it was revealed, because the technician who burned the DVD realized stuff had not been listed in the report he'd initially prepared, he was afraid he was going to face legal consequences for this. So he lawyered up, and it was exposed. And when the defense naturally went crazy and said, Your Honor, they're hiding exculpatory evidence from the defense, the prosecution's answer was, no, we gave it to you. It was on the DVD. All you had to do was sit there and watch the DVD.
Wow.
One of the nastiest thing was on that Rittenhouse trial, when the state presented a doctor, basically a less resolution video. You remember they presented it,
right.
And they had that software that was compressed it and made it less resolution, and they got past the judgment of acquittal stage based on the inconclusive nature of that video that they provided, when they in fact had a clearer video. Do you remember that?
Yep.
That was pretty darn dirty.
That's just all wrong. It's wrong.
Where's
It's
the
a violation
consequence?
of your duty of candor to the tribunal. It's a violation of your ethics obligations 8 different ways. I mean, you can't do that.
But it happens. And if
rarely
Rittenhouse had been convicted, he'd be sitting in jail right now, maybe with a hope of an appeal. But
Yeah,
most
and
appeals
good luck
lose,
on that,
folks.
right?
Almost
'Cause
all
good
of them,
luck.
right? Appeals are for losers, as
They
we
are for
say here at
losers.
Law Self-Defense.
Yeah, they're for
Yep.
losers. Because you have to show his rights were violated, then you have to go show it mattered, and
the chances
then your
of a
remedy,
criminal
then your best remedy is a new trial, and we
the
do it all
chances
over
of
again.
a criminal defendant getting a positive remedy, that means something like a new trial, could be a new trial, could
It's
be
not an
a new
acquittal.
No,
not
it's
an
not.
acquittal, is 0.6%. That's 6% out of 6 of 1,000. 6 out of, not 6%, 0.6%. That's in my district where I practice and I do appeals. So, and that's, I just had a case where somebody got out of prison after 10 years, went from 10 years in prison to not guilty. That's only about the 3rd time I've ever had that happen in 12 years. So very, very, very rare do you ever see somebody getting out of prison on appeal. You might get 10 years knocked off a 30-year sentence, or a new trial where you get reconvicted. So that appeals is not the way to go. You got to win at trial. And when you have cheating prosecutors, it makes it very hard. And that Rittenhouse maneuver was really dirty. And they did it because it was a big high-profile case.
Yeah.
They're willing to do it in a big high-profile case. What are they willing to do in the non-big high-profile cases, right?
Exactly.
They're
Yeah.
willing to
Where the
cheat
whole
on the
world's
biggest
watching.
open stage.
Right.
The whole world is watching, right? We're all there. We're all watching the trial live on YouTube and commenting on it every minute in real time. And they're doing it in our face. It's amazing. At least in that case, we knew for a fact that the defense team was at least had some people on the team who were watching our commentary on YouTube because we could see they were changing their strategy. And after the trial, we had a chance to chat with some of them and learned for sure that was happening. So that was nice. The same super chat, Zenothium 15, also asks, on a serious note, could the girlfriend in this case, the Bodega case, face any charges? Yeah, she could. She stabbed somebody, right? And so you can always potentially face charges if you stab somebody. The trouble is her defense to any use of force charge is going to be, I perceived that my boyfriend was being unlawfully killed, subject to deadly force, and therefore I was defending him with proportional deadly force. And then the state has to disprove that claimed reasonable perception of what was happening beyond a reasonable doubt. Even if there were no politics involved, and clearly there are, there's no political benefit to this prosecutor going after the girlfriend, for example. It would be arguably a difficult case to win.
And there are some other possible charges if you had a creative and smart prosecutor and if they wanted to charge her. But I don't think there's any willingness to charge her because, for example, you could charge her with some sort of accomplice liability for bringing him in and facilitating this transaction. And so you could have that, but it takes a willing prosecutor, and they're not going to go out of their way to charge her because of the politics involved. So,
and I'm not sure it's an easy case. I mean, so you can say, I'm going to get my boyfriend to come here and kick your ass. And sometimes you mean it and sometimes you don't, right? Sometimes you just want your boyfriend to show up and yell at somebody. On the other hand, sometimes your boyfriend's a psychopathic murderer and you know it, and you know he's going to tune that guy up.
Well, if you can show that she knew that, sounds to me like recklessness to me.
But how can
you're under reckless homicide?
Why didn't she get her boyfriend to come in and pay for the chips? Would that be so difficult? Such a high expectation?
For the $2 worth of chips, yeah.
$3, yeah. Come on, give me $3.
Dead bodies over
behind her, I would have
chips.
said, "Here's $3, right? Take the chips."
Hey, listen, when I worked that job in a convenience store, we would have people come in and steal stuff all the time right in front of me, and I was not prepared to die for a convenience store job. And I would tell the owner, I'd make a note, that's what they told us to do. Just make a note of what was taken. And eventually, of course, they shut the convenience store down because it was losing money hand over fist. Every once in a while, they would have the local PD send a cop over and he'd stand in the store. And of course, while he was standing there, nothing would happen. But, after a couple of days, he'd go back to whatever his normal duties were. And they'd come right back in and steal all the stuff out of the store again, especially the beer. They liked that a lot. And there wasn't anything I suppose there was stuff I could have done about it. There was nothing I was willing to do about it.
Then the stores closed down and people become more bitter because the stores aren't there.
Yeah, we have a food desert then.
I mean, what are we talking? It's all bad news.
Here's a $5 super chat from Crusader Saracen. Says, imagine fighting and dying over your woman's bag of chips. How sad. Yeah, folks, I have a video I captured just the other day, maybe 2 or 3 days ago. A couple guys just kind of almost chest bumping. It looks like in a subway tunnel, some kind of, and one of them had a knife and punches the other guy in the neck with the knife. And absent the knife, it would have looked just like a punch. And I'm pretty sure the guy who got hit in the neck thought it was a punch because he's just standing there. But man, his carotid got hit and the blood just, it dumped out of him.
I saw that. He probably didn't know he was dead. He probably
didn't know he was dead. So he's standing for 2 minutes, maybe. He's still standing there. And then, of course, the blood pressure drops. He gets dizzy. He falls over. But he was a dead man from the moment that blow struck. And that wasn't even over a bag of chips. That was over nothing except testosterone.
Well, most cases that I deal with, and I do a lot of murder charges, I have a lot of trouble determining what the motive was. And there's very rarely any benefit at all to the murderers. And that's what the problem is family members really hate that because they want to ascribe meaning to the death.
Right.
Why did this happen? Why did this happen? When in fact, meaning comes through your life and how you live your life. We're all going to die. How we die does not determine the value of our life. It's how we live our life from day to day that makes the difference. But people, what happens is many of these decedents don't have much of a life to look back on, and then they want to create they pour all their unresolved issues into this death to make it meaningful. When most of the time it's not.
It was meaningless.
Reason.
Literally meaningless.
Yes.
All right, CRJR asks or says $10 super chat. Thank you very much. Says this went away because of the publicity and the fact that there was video. If the video didn't exist, a prosecutor Bragg would have prosecuted Mr. Alba, and the deceased would have a street named after him.
Damn straight.
Seems likely.
Damn straight.
Yeah.
Crusader Saracen, and again, another $5 super chat. Just as important as knowledge of the law is basic wisdom. If he hadn't picked the fight over chips, he'd still be alive. Don't start fights. You never know. Yeah, for sure. Don't start fights, folks. That's always a bad idea. It gets a little more complicated when the fight's coming to you and you panic and start making bad decisions. That's where normally law-abiding people tend to get in trouble.
If withdrawing and running away is an option, it's very advisable.
Yeah, absolutely. The most common cases I consult on are aggravated assault with a firearms case, where you have someone who's a law-abiding person, never been in trouble with the law a day in their lives, has a concealed carry permit, has a gun on their person, gets scared and pulls out the gun. Normally, they don't fire a shot. They don't hurt anybody, but they display the gun in a threatening way in what they genuinely think is lawful self-defense, but under circumstances where the prosecutor feels going to a gun was not justified. And they get charged with aggravated assault with a firearm. And in most jurisdictions, that's good for 10 to 20 years in prison, folks, if you get convicted.
But, so another point on that, too, is that something that I've had to deal with personally that I've never really thought about in a law context. That's the fight or flight response. And it's a very real thing that when you get confronted in a situation, if you do not have a thought out plan of dealing with something, your body, you will respond either by fighting or flighting. And I found out during my fight or flight that I'm a fighter, but that might be the wrong. In fact, it was the wrong response in the type when I was confronted with that situation. It would have better had I fled. But it's a primal instinct that is deep within us that when you are confronted in a high stress situation, it will happen. I think the best way to deal with that is to think through scenarios. Keep yourself out of bad scenarios, but think through scenarios where you might be confronted with the use of force and think about how you will respond to that rationally, so that when you're confronted with that and you feel the emotion and the rush and you're prepared. It's not the first time you've thought about this. Exactly.
Very important. A great question here. Someone, Colleen Griffith, $10 super chat, asks, what brand of pepper spray do you carry? I guess meaning me. I carry Saber brand. I don't claim any expertise on pepper spray, but I've been trained by people who are experts with pepper spray, and they recommend to me Saber or alternatively POM, P-O-M. I think you can get both of them on Amazon, depending on what state you live in, and they'll ship it to you, I guess. But Saber, S-A-B-R-E, or POM. POM comes in a smaller package, maybe convenient for some people. I've carried the Saber product for years. I like it. And that looked like a Saber OC canister to me in that image we saw in the convenience store. But folks, one of the reasons that the cases I work on, those clients got in trouble was the only defensive option they had was the gun on their person. They didn't have pepper spray. They didn't have any barehanded skills. And if you look at the Department of Justice FBI crime statistics, you're 5 times more likely to be faced with a non-deadly force assault than you are with a deadly force assault. So listen, when a gun is the answer to the problem, a gun's generally the only answer to that problem. But most of the time, the gun's not the right answer to the problem. But if all you have is a gun and you get scared, people go to the gun. They go to the only thing they think can save them. And a great way to make sure that you don't do that out of panic is to have other options, have non-deadly defensive options. I carry a gun every day. I have my entire adult life for personal protection of my family. And every day I have that gun on my person, I have my pepper spray too, just in case I have the opportunity to use that without having to go to the gun. Let's see. Ofix, $2 super chat. Come on, man. You can do better than $2. Interview with Guy Relford, Eli Dickens' lawyer, maybe. I'm not sure I know those names. Guy Relford? That rings a bell vaguely, but okay. Hey, if you want to leave a bigger super chat, I'll research it. Matt Nucci, $4.99. Thank you, Matt. Lady leaves threateningly, returns with aggressor that corners Bodega guy. She then stabs, presumably in self-defense. Do her actions before this count? I'm sure they could count. And they could count, for example, and Steve brought this up earlier, if a prosecutor was exploring a felony murder charge against her, that she was in essence an accessory to this crime that developed into a murder, even though the victim of the murder was her boyfriend, the fact that she did all these things certainly can play a role. The stabbing, maybe. The trouble with the stabbing is her stabbing of Alba happens after Alba's begun stabbing her boyfriend, and that provides the possibility for a narrative of defense of others.
Well, here's the narrative that you could construct, and I don't know the facts well enough to know whether it supports this theory, was that she entered that with her boyfriend in an attempt. It was a robbery attempt. So it was an attempted robbery. If that can be, if an attempted robbery could be projected onto that situation, then she could be indicted under a felony murder rule. So if somebody dies during the commission of a violent felony, such as a robbery, then you as a co-conspirator are liable for the death, even if it's your co-conspirator. So in that scenario, she could be charged. Now you'd have to frame this, what happened here, as an attempted robbery, which isn't that far. It's not, it's as close as you could charge this guy with the homicide, right? So, I mean, I think it's a matter of political will on the prosecutor's part. They could have gone either way with this.
Well, I'm not sure that I've seen evidence of a robbery because
what is he saying? I think it really depends on the words that were being exchanged.
Yeah, right, exactly. But it could easily not be that, which is a problem when you have to prove the robbery beyond a reasonable doubt, right? As part of that.
I'm just thinking about theories.
I think what the girlfriend would say is, I came in to pay with the $3. My card was no good. He tried it a couple times. She's going to say, although I don't hear this on the video, he was rude to us. He was insulting to us. And that's why I went to get my boyfriend, not because we were trying to steal property, but because I didn't like the way I was being treated.
But a prosecutor doesn't have to believe that. If there is some evidence that they were trying to take the chips.
But was there? I mean, have you seen that?
I don't know. I'm just throwing out ideas.
Yeah. I mean, if there is, sure. If they're trying to run out of the store with property, then it begins to look a lot like a robbery.
Go shake him down and tell him he should have given me the chips without paying.
Yeah, that can happen. That can happen, but I'd want to see something to support that, right? Like, hey, just give us damn chips. We don't have to pay for anything here, right? This is our neighborhood. I mean, if there were words to that effect in the video, that would change everything in terms of that. Okay. $10 super chat from Mexican Iron Man. I don't know why you people make me say things like this, but proud to be a member of this channel and proud to be a paying Hard to Convict program member. Well, thank you very much. Your book was great. Thank you even more. Thank you for all you do. P.S. John Farnham sent me to you. Mike from South Carolina. For those who don't know, John Farnham is a very, 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 very good firearms instructor here in Colorado. He's been teaching for many, many decades. If you ever have the opportunity to take one of his classes, and he still teaches, he's getting up there in years, but no offense, John. But he still teaches, him and his wife, Vicky, still teach every year, all year long. So if you have a chance, he's north of Denver in the Fort Collins area. I would absolutely encourage you to take that instruction. It's world-class stuff. Let's see if anything else has come in. Oh, a couple more, I think. Let me see.
Here's a question for my criminally law-minded people. Can I after passing the Texas bar, move to Uvalde, run for prosecutor, and charge every police officer in sight with 21 counts of involuntary manslaughter? I'm going to have 376 people times 21 counts plus dereliction of duty. It's going to be the greatest indictment ever. Is that too much?
Well, I'm not sure you can get involuntary. I mean, there ought to be some kind of malfeasance criminal charge here, right? For them clearly not doing their duty and then let them defend themselves in court. I mean, it's hard to provide any rationale for why they did nothing while they were standing there. And if you're going to do nothing, don't take the damn job. Don't put the badge on.
And they actively prevented people
others from going in.
Well, but there's a lot of immunity to police in their uniforms doing their job and the duty to protect. And it's actually judicially created. It's a problem. I know Glenn Reynolds at Instapundit rails against judicially created immunity statutes, especially when it goes to prosecutors also. So that's an uphill battle, and one that is in need of careful look and reform. The problem with our political environment is that we don't have good faith actors on both sides. And so if you have people that just hate cops and then that drives the cop supporters to any kind of reform is a slippery slope, and so there's no trust. If there was trust on both sides, then we could have a rational discussion about what standards should be applied, and I think there could be some reform in that. And I think there's probably a lot of agreement in the general public to those things, but it's too easy to politicize. You're anti-cop, you're pro-cop, and then we just don't get anything done.
I'm anti cops standing in the hall as they are hearing the shots and the screams coming from inside, cleaning their hands rather than trying to, take steps to intervene when they are as armed and defended and have the shields and body armor and weapons and tactics and training and support and staff as they do. That's what I'm anti.
Yeah, I mean, I've never been a cop, but I've worked with a lot of cops. I've done a lot of training with cops, and my understanding of all the training for this kind of situation post Columbine, is you hear those shots and you go hunting in the school.
Yep.
But
yeah, and there was a woman.
Parkland.
There was a woman just charged in Pennsylvania. A 911 operator was just charged involuntary manslaughter for not sending an ambulance when 911 was called. She didn't believe that the person would actually go to the hospital, and the person died the next day from blood loss or whatever. And so they are charging her for basically involuntary manslaughter, the underlying, thing being she violated her duty by, violating her flowcharts, which basically required her to dispatch the ambulance, didn't allow her to make any kind of independent judgment. So
criminal charge or civil?
Criminal charge, yeah. It's unusual. It's rare. It's why it's worthy of note.
Yeah, interesting. I'll send me something on that case, Kurt. I'll take a closer look at that. The trouble is, it happens so rarely that such cases just don't come across our radar screen for us to comment on or develop much expertise on.
Well, fortunately, what I do have going for me is that all the qualified immunity doctrine doesn't work against me in my my quest against the Uvalde police, because that's not a criminal law concept. It's only a civil law concept. So I got that going for me, so I don't have to deal with, if you're going to try to sue these cops, you might have some Texas state-specific law that allows for it that I've heard talked around. But if you're trying under federal law, it's a total non-starter because of, Deshawney versus.
Well, it depends on what you're suing over. I mean, it gets a little complicated. Most of these suits against the police are federal 1983 suits. And
right.
That's where we see the greatest application of qualified immunity.
Correct.
To excuse the officer from the suit. And frankly, in my experience, it's kind of an implicit understanding that you're not leaving the harmed person with no recourse. You just expect them to go after the department as opposed to going after the individual officer. Yeah, because you look at like Tennessee versus Garner, for example, all the famous Supreme Court use of force cases. Those are all cases in which the officer was dismissed from the case long before it ever got to the Supreme Court on the grounds of qualified immunity, but the case still went forward even without the officer attached.
Yeah, because you're usually in those cases trying to find some sort of independent practice training from the city, the police that has a bad policy to find their liability.
Right, and they have the money.
Then you have another problem on the qualified immunity issue.
Right.
So
okay, Nathan Levy, $4.99 super chat writes, Kyle's law would solve political prosecution. So I don't know if you guys are familiar with this, but after the Rittenhouse case, I had proposed something I called Kyle's law. To try as basically a thought experiment. I'm not in the business of actually sponsoring legislation or advancing those kinds of things, but just a thought experiment for maybe others to advance if they had the interest. And the idea is this: if a prosecutor is bringing a use of force charge in a self-defense case, they know when they get to trial, they're going to have to overcome that claim of self-defense beyond a reasonable doubt. You could, in theory, have a special jury form that asks the jury, hey, assuming that you acquit on the basis of self-defense, do you all agree, or a supermajority of you agree, that not only did the prosecutor fail to overcome self-defense beyond a reasonable doubt, that's evidenced by your acquittal, but they failed even to disprove self-defense by a preponderance of the evidence? And if the jury agrees that the prosecution didn't even meet that threshold, which really is what probable cause ought to be in the first place, that the prosecutor could be held personally liable for that defendant's legal expenses. So, and the purpose of this, my intent is that it would disincentivize prosecutors to bring charges in self-defense cases unless they had a realistic belief that they could at least achieve preponderance on the issue of self-defense. When they know to get a conviction, they're supposed to get beyond a reasonable doubt.
Interesting. Well, I have proposed in my paper on prosecutorial misconduct in closing arguments that there needs to be mandatory reporting for prosecutorial misconduct, which, the self-defense thing, I'm not sure, that you're the expert on that, but, what we deal with a lot at the trial level is prosecutorial misconduct, and it goes unreported because who's incentivized to report bad prosecutors? A defense attorney has to work with people over time, and they don't want to make anybody angry, other prosecutors, friends, judges, whatever. Judges don't want to do it because somebody will run against them in elections. Nobody ever wants to hold prosecutors accountable for bad ethical behavior.
Right. Well, there's two parts to that, right? First, someone has to decide it was bad conduct and say so. And then you have to be willing to require them to report it, right?
Right.
No one wants to say to a prosecutor, I mean, we see these cases where the prosecutor's out in an outrageous fashion, and even the judges don't hold them accountable. I mean, the judge is watching this happen in their own courtroom, and sometimes the judge gets mad in the moment.
Look at the guy with the video that happened in Rittenhouse.
Right.
Did that judge send that to the bar? He should have. Remember, he railed up and down with him.
But nothing happened. And so,
but
and
it
it's because, as you say,
report.
these are all players in the same system. They're going to see each other again. Right. They all see each other all the time in the courtroom, at the country club, wherever it is that they bump into each other in social and professional settings. That's why my proposal for Kyle's law actually strips that authority, or at least doesn't require their involvement. It's up to the jury to decide. And if the jury returns that jury form, then the defendant has, in effect, a private cause of action against the prosecutor for reimbursement of legal expenses. And there is a precedent for this. So in the state of Washington, they have a special jury form just like this. And it asks the jury, hey, do you agree not only that the defendant was acquitted, so the prosecution failed to disprove self-defense beyond a reasonable doubt, but that it wasn't even a preponderance argument to overcome self-defense? If the jury agrees, the state is obliged to reimburse that defendant. So what I'm proposing is a variation of that, where maybe the state pays half and the prosecutor pays half, but I'm trying to get the prosecutor to have some skin in the game himself, because let's face it, it's not the state making these prosecutorial decisions. It's the individual prosecutor himself.
Well, sometimes the young prosecutors that are made to sign these pleadings are coming in out of law school, and they don't know, and they've got debts to pay, and their big boss is pressuring them to file things and do things.
Unsympathetic.
Well, I'm just giving you. There's a lot of sides to that.
Yeah.
I'm not against it. I'm just saying that it's there, a mandatory reporting for the ethics, and also, if somebody is acquitted, they do have rights under federal law to sue certain agencies for civil rights violations, but you need to have an acquittal. So you can't have a plea, you can't have a conviction of any sort, but if you get not guilty, you can then proceed to federal court under civil rights violations, but that's an uphill battle. You've got to have damages and everything else.
Yeah, I mean, I'll take your word for it that that's a theoretical path. I've never seen it happen in a self-defense case I've covered.
Well, but no, the prosecutors are absolutely. It's not it would be against the police agencies generally.
Yeah, I'm talking about cases like George Zimmerman, for example.
Right.
I know for a fact he's never had any kind of.
But how common is that? That's my question. I would say, how is that relative to the prosecutorial misconduct problem, which is huge? How common is wrongful?
I've never seen it, because most of the time when the person's acquitted on self-defense, it's presumed that the prosecutor acted in good faith. So what you're talking about, I could imagine happening if exculpatory evidence was hidden, but not merely because the person was acquitted on the grounds of self-defense. I mean, acquittals happen.
Mm-hmm.
Let's see. 0. Okay. I got to say it, I guess. It's the number 0, FUX, which I guess would be pronounced zero fucks.
You said it. Hey.
Guy Relford is the lawyer of the Indianapolis mall shooter. Okay. Would be interesting to hear to talk about self-defense of others. He's a firearms guard too. I don't know him. If you know a way to reach out to him, I'd be happy to have him on the show. I do plan to do a separate show. And by the way, Steve and Kurt, if you'd like to be on that show, I'll
there's a hero who didn't sit around in the hallway for 5 hours. Did you see the Babylon Bee wrote a great article, a little mock article? No, they wrote a great article from the mock press conference from the Uvalde police, chastising him for actually going in and fighting off the bad guy instead of waiting around for hours.
Yeah,
that's why we're trained professionals. You're not supposed to do that.
So I do plan to do a show on that from the perspective of what kind of legal risks do you run if you decide to be an intervener in what you believe to be an active shooter event? Is it zero, or are there legal risks that you run? Because they're low, but they're not zero, folks, and you want to be aware of that. Now, for example, I don't know if does anybody know how many hits that Indianapolis shooter got on the bad guy? Because he was firing, apparently, it's reported from 40 yards away. I'm a guy who's fired well over 100,000 rounds through handguns in my life because I was a very active competitive shooter with handguns for a very long period of time. 40 yards is a damn long shot with a handgun. It is a very long
shot for a handgun,
yeah. To get sufficient hits to terminate a threat. Now, I know, or at least it's reported, he fired 10 rounds. I would be shocked if anybody got 10 hits with 10 rounds at 40 yards. I mean, that would be world-class competitive shooting.
You're going to meet my friend Chris. He could do it.
Yeah. Well, okay. Fair enough.
Yeah.
But I'm wondering,
it is high-level stuff. That's not easy. I mean, I can't hit. Well, I'm pretty good. But, I mean, I usually, when I practice handgun shooting, I usually practice within 10 yards. Because
sure.
If you're shooting further than 10 yards of handgun, you're probably shouldn't be shooting because that's far enough away. I mean, you got to be careful. Those long range shots, those are rifle shots, right?
Right. But, what you're saying is true in a self-defense scenario. Because if it's more than 10 yards, unless the other person's also armed with a gun, but absent that, it's probably not a self-defense situation. But defense of others, it's not uncommon to have these long distance shots because the defender, the intervener, is seeing an event that's happening at some distance where innocent people are being victimized by a bad actor with a gun. And so they're compelled to take the shot in defense of others at a relatively long distance. As what
shooter did the mall shooter guy, was he armed with a rifle?
No, he was armed. Well, the bad guy was armed with a rifle.
Bad guy had an AR.
Yep. Which, by the way, folks, should be a horrifying thing to contemplate. Going to a gunfight where you're armed with a 9mm Glock pistol, as this intervener was in Indianapolis, and the bad guy's armed with an AR. If that bad guy knows how to use his AR and he's aware you exist and you're trying to stop him, listen, my 13-year-old daughter can use an AR and hit a head at 100 yards all day long without any effort at all. That's
the rifle is the weapon. It's definitely the one you want to be. You want to have the rifle in those situations for sure.
So I am going to talk about that case because, for example, here, let's assume he got 2 hits on the bad guy, which was beautiful. That's amazing shooting. 2 out of 10 at 40 yards, sufficiently center mass to stop the threat, neutralize the threat. That is unbelievably great performance. It also means 8 misses. And presumably a crowded mall, where are those rounds going? Because bullets don't miss. They keep going until they hit something, right? Now, is that still defensible conduct? Absolutely. I'm not saying it's not defensible, but we can talk about the legal doctrines that would make that legally defensible, even though you're arguably creating risk to innocent people. And yes, it is different when the police do it, folks. It shouldn't be.
It shouldn't be.
But
every law I've read doesn't distinguish.
Yeah. No, the black letter law makes no distinction, but for whatever reason, we tend to treat as a practical matter, the police misses with tremendous generosity because they miss a lot, even at incredibly close ranges. Police, I always laugh when I hear the gun control community say, "Oh, like people with concealed carry permits should have to meet police standards." I'm always like, "Do you know what police standards are?" Because they're really low, and they're
Well, I advise, it's amazing doing depositions of police officers and how little they know about firearms. Not all, but I've interviewed some cops. They don't know anything about firearms. They don't know how to shoot them. They don't know how they work. It's like they have to get through the minimum qualification. And, in all honesty, good police work usually does not involve a firearm. Usually they're taking reports, they're arresting people. There's, a lot of cops go through their entire career and never have to fire their weapons. So I'm not condemning. I'm just saying that it's funny because I'm kind of a gun guy and I ask them questions. They're like, I don't know
that. Tom O'Connell, $5 super chat says, be careful with women that book your fights. Yeah, folks, don't let the ladies book your fights. That's a hell of a reason to get into a fight. And remember, folks, anytime, the moment you get engaged in that confrontation, you just incurred 2 risks you were not incurring a moment before. A risk of dying in that fight can happen in an instant. We're all a 50-cent box cutter away from sitting on the curb with our hand on our neck, watching all the blood come out of our body. and a greater than zero risk of getting
Yep.
convicted and sentenced to prison for the rest of your life without possibility of early release should you kill that other person under circumstances the jury decides was unlawful. You don't control those risks once you're engaged in the fight. You don't make judgments about whether or not your use of force was lawful or not. That's all in somebody else's hands. The moment you're engaged in that fight, you've put the rest of your life in other people's hands, people whose interests may not be aligned with your interest. It doesn't mean don't ever get engaged in a fight. Just make sure that the stakes you're fighting for are worth those risks, because those are the risks. Pope Rackets touched me. Okay. Thanks, guys. I love it when you say my name, Daddy. LOL. That's a $2 super chat. I gotta set a higher minimal floor on these things. Stephen Dale, $10 super chat. Thank you very much, Stephen. Asked, does the observance of jailhouse tats on an aggressor constitute prior knowledge? Does user of self-defense's prior LE experience change your defense of him or her? Everything that the defendant knew at the time they were involved in the use of force event arguably goes to their subjective state of mind. So yeah, it would all play a role. If they have training and expertise in identifying criminal tattoos and what those tattoos may mean, and some of those tattoos do have specific meanings, how many people may have been killed or other crimes that may have been committed. It's like a code that some criminals wear. Yeah, if you're capable, if you have the education and training and expertise to interpret those tattoos, that would go to your reasonable subjective perception of the level of threat you were facing. And the same with police officers who have a certain level of training and experience in violent conflicts, whatever they knew at the time. And by the way, same for civilians who pay for their own training in self-defense. That's all subjective knowledge. You take a law self-defense class, we give you a certificate for a reason, so you can document your training. That all goes to your subjective state of mind, and you need to be able to show the court that you possess that knowledge at the time and didn't just learn of it afterwards. Because if you learned of it after the event, obviously it could not have informed your decision making at the earlier event. So whatever you're thinking, I'd like to be able to introduce as evidence to explain why my perceptions, decisions, actions were reasonable. Well, you better be able to document that you possess that knowledge prior to the event having happened. Otherwise, you might find that the trial judge won't allow it. That stuff gets excluded all the time because defendants are unable to document that they possessed it at the time.
And especially when they tell the cops that they didn't possess it at the time.
That's the one.
Yeah,
that's
they're talking to them. They're talking, and they think they're talking their way. And all of a sudden, there's all this history that I could use, but they've just excluded it by questioning. And it's a high-pressure situation. I think you brought up earlier that I think the police unions actually have a contract in their contract that they get 24 hours to wait before they're interrogated on any police.
I've seen that.
Yeah, so, but that doesn't apply to us civilians.
No.
Yeah.
Unless you ask for it, because you can always
ask.
invoke that right to remain silent, and that would be a good thing to do.
You invoke your right to remain silent and your right to counsel, and you stick with it.
Mm-hmm.
And don't expect the lawyer to come parachuting in. Sometimes you have to wait a week or two. Right. Yeah. But your life is on the line. You want to keep your mouth shut for sure.
So I've never worked in a really rural area, but I know some sheriff's deputies who work like in rural areas of Georgia who tell me that they basically have a magistrate come through their county like once every few weeks. And so if you get arrested, especially on a felony charge, you could be sitting in that jail waiting for a magistrate to get bail for 2 to 3 weeks.
Well, in Florida,
the memory serves, didn't the Supreme Court require like an initial appearance or something within 72 hours?
Exactly. Yeah, there's in Florida, I don't know, I can't speak for other states, but we have a 24-hour appearance rule, and so we have first appearances. So as public defenders, we're always out in the court. We have to show up at jail even on holidays for first appearances. Now they do have video first appearances, but and sometimes it'll roll to 48 hours.
So that might have changed things. Even
right now, I'm just looking at my perspective and what I see. But the thing is, all first appearances is your right to bail. If you've shot somebody and you're accused of murder, that's a zero bail. That's no bail. So you don't get it. You don't get bail. So then you're talking about 30 days for a charging decision, and then you have arraignment. So if you're charged, so it can be a little bit of a wait there if you're no bonded on a serious a shooting case. We're talking about serious stuff here. And that's Well,
or
they'll
you
usually,
get a bail that's impossible to meet. I mean, what was Rittenhouse's bail? 2 million,
yeah,
and
which
it's
he
only
somehow
because
managed to come up with because of the
right.
GoFundMe, which led to its whole set of drama, as we remember. So yeah.
Yep.
right. Interesting, yeah.
And he had to pay for that all, incidentally, which is not a typical rule.
Well,
Because
I
most
think
states it's
CNN's going to
10%.
end up paying for it in the end.
Fair, true.
Okay, let me see if there's anything else before we move on. So yeah, folks, keep your eyes open. Probably sometime tomorrow morning, I'll try to schedule something on the relatively brief on the Indianapolis mall shooter event. Clearly, it was a good shooting, but there are some legal dynamics around the case that you ought to be aware of should you ever find yourself in a similar situation. Things to think about before the event. Like all these things, we want you to think about it before the event. You don't want to find yourself in that position cold. I would expect if someone were to ask this Good Samaritan shooter in Indianapolis if he'd ever thought about this possibility before, he'd say yes. That he wasn't coming at this cold. He'd at least contemplated it in a thought.
Well, in my church group, we have a church shooting group, and my deacon tells me that, we have a moral responsibility to protect the innocent. So I think that there is a higher level of duty. You don't have to protect yourself. You don't have to act in self-defense. But if you see innocents getting gunned down, then you do have a moral duty to act if you can. So that's kind of one of the reasons I carry. I don't really even carry for protection of myself, although if I had to, I would. But I'm always thinking about the active shooter situation when I'm concealed carrying out in the public, because, like somebody coming into our church and shooting people up, which is not unheard of. Yeah. And, I think I have a duty to protect those innocent people. And that goes, that's what I do, hopefully in my career, but also when you're concealed carrying. So, and people have different faiths and different things, but I always thought that was an interesting insight from the deacon.
where people tend to get into trouble, to my mind, there's really three classes of defense of others situation. There's defense of others where the others. They're your family, they're friends, they're coworkers, they're colleagues, they're people so you have some sense of whether, for example, they were likely to have been the unlawful criminal aggressor in the fight that you're intervening in, right? And they share an interest in you. They're your family, your friends, your colleagues. They're unlikely to testify falsely about what you did, right? Like the girlfriend would be happy to testify falsely about Alba here, right? Presumably. Right, yeah. Then you have a second class of defense of others, which is defense of strangers, where you turn a corner and you see a fight happening and you intervene in that fight. Especially if it's a fight involving a man and a woman, a domestic kind of situation. I mean, just ask any cop who's ever intervened in a domestic, which means just ask any cop. They've all intervened in a domestic.
They hate those.
How quickly they might put hands on the guy beating the woman, and almost instantly the woman turns on them.
Yep.
And that's going to happen to you too, folks, or at least you run that risk. And suddenly the person you were rescuing is telling everybody, right, the cops, the prosecutor, the jury, the judge, that you were the problem.
How does that make any sense to anyone is beyond me. But yeah, you're not wrong. You're not wrong. You go out of your way to be a good Samaritan, be a good guy, try to save someone who is obviously in distress, and suddenly they're fighting you and now saying that you're the aggressor and all the rest of it. It's like, how did my life come to this?
Yeah, well, you put yourself
what's wrong
there, is what happened. And by the way, when you see these situations like a woman attacked on a bus or a subway car and everyone just stands around and doesn't do anything, and you see the comments and everyone's saying, I can't believe everyone stood around and didn't do it. Well, that's because sometimes when people intervene, they end up getting prosecuted. Right. And so they don't want to risk that. Or they're getting hands-on in a fight. So they're running that risk of themselves dying in a fight or being criminally prosecuted. For who? For someone that may well not thank them anyway.
And there's a limited knowledge. It's dangerous too, because you're operating with limited knowledge. You don't, like you say, you only see part of this thing. You don't know the big picture and who's who the good guy and who the bad guy is. So you got to be very, very careful in those situations, because you don't know really what you're dealing with.
Right. So I mean, I've been involved in cases where Good Samaritans intervened in what looked like a serious fight. And it turned out the person they thought was the victim was actually just the suspect being subject to lawful arrest by plainclothes officers.
Right.
And so they pointed a gun at the plainclothes officers. Yeah. Well, listen, you point a gun at cops, that's going to be a bad day. And by the way, when you point guns at cops, they tend to point guns back.
Or shoot you.
Or shoot you. Right. So you have defense of others, people then you have defense of others, strangers, which is a very strictly speaking, the black letter law is the same. It doesn't change, but the practical dynamics are extremely different. And so the risks are extremely different. And then you have the third bucket of defense of others, which is the active shooter situation. And of course, those people are strangers too that you're defending. The difference is there's no ambiguity about what's happening. Some guy's walking through a mall with an AR potting people. There's no ambiguity about who's the good guy and who's the bad guy in that situation. So you don't have those particular set of risks.
On a sideline, did you see the Domino's pizza guy who rescued the 4 or 5 kids from the fire? That was, talk about heroes. Yeah. And I mean, that is what we really should have some good Samaritan laws. And I know that that's something that you have some knowledge on, but I don't see that too much. But boy, we want to encourage citizens to protect ourselves. I think, I don't like this.
And mostly good Samaritan laws protect you from civil liability and not primarily criminal liability. So, I mean, we're kind of trusting in the discretion of prosecutors to not bring criminal cases in those situations. And that's, we give prosecutors enormous power and discretion because in appropriate hands, that's what you need to do the job correctly. I mean, really, they need enormous power and discretion. But when that same power is put in politically motivated hands and you start getting politically motivated prosecutorial decisions, that's a bad day for that community. And we see that effect happening all over the country right now. And unfortunately, a lot of these prosecutor seats are effectively available for purchase cheap. I mean, a few $1,000s and you can win that race, even if you're a complete outsider, even in sizable cities, which is what George Soros has done in so many cities. And we see the chaos that results. So it's unfortunately the only real check we have is the electorate to don't vote these people in. But the electorate's so poorly, and nobody knows who their prosecutor is. They're so poorly informed about these races that it's just a name recognition check on the box or a party alignment check on the box. And these lunatics get elected prosecutors with all the power and authority that we've traditionally put in the hands of normally responsible people.
But it's hard to mandate competence.
Yeah, it is.
And that's the thing. I mean, when the society is being devolved through media, mass media, and poor education, that ultimately the whole criminal justice system stands or falls on a reasonable jury. And if you don't have reasonable people in your population, no system that you graft on it is going to succeed.
And really, the jury comes too late for a reasonable system. I mean, you look at cases like Zimmerman, Rittenhouse. I mean, they got acquitted, but it's a life-destroying process. I mean, better for Rittenhouse than for Zimmerman. So ideally, you have a prosecutor who's also a reasonableness check before you subject someone to the trial process to begin with, or you have something like self-defense immunity, like you do in Florida, where you have an option, kind of a.
But then you need a reasonable judge.
Then you need a reasonable judge, right? But at least if you have it's a way to step around a unreasonable prosecutor, assuming that you have a reasonable judge.
But again, this all goes back to a reasonable population, because a lot of the effects that we're seeing in the criminal justice system are a result of, over time, a unreasonableness being injected, a lack of people just playing their roles, like understanding their roles within the system. That a prosecutor is not an advocate for guilt. I mean, a lot of these things are ethical and moral questions that our society has lost. We've lost a lot of the language of moral and ethical dialogue, and maybe even the commonalities, so that we can't even talk about good and evil or right and wrong or what's ethical and what's not. It becomes hyper technical and then subject to almost political whim. And it's a mistake. I think it's a societal problem, and we're talking about it this way because we're in the criminal justice system, but we're downstream from this culture that's feeding into, people who aren't following the law, people who are playing political games with the criminal justice system. Those are people that are making decisions based on a lack of values, a lack of faith, a lack of ethical language, so to speak. And not playing the roles. Like I said, I mean, it's not the defense attorneys that are advocating too strong for their clients. It's the prosecutors betraying their principles, or the judges betraying their principles, or jurors betraying their principles, like convicting somebody because their race, or letting somebody off because of that, not following the law. Those are all problems, but it comes back to the human beings that are populating the system throughout.
Yeah, I mean, we have a super chat here from thanks, guys. Suck it. $5. Writes the leftist Hillsborough prosecutor allowed a person of color fast food worker to walk on a murder charge of an elderly man because of the popcorn shooter verdict, the Curtis Reed's verdict. I remember that being in the news. Clearly just a racially energized political decision by that prosecutor. They have the discretion to make those decisions, not to charge someone, folks. That's entirely within their purview, and there's nothing anybody can do about that. For the most part, there are exceptions. I mean, famously in the Zimmerman case, the local prosecutor refused to charge George Zimmerman. They had very extensive meetings with law enforcement, with the prosecutor's team over a period of weeks investigating that case, and they ultimately concluded it looked so much like self-defense there weren't grounds to bring Zimmerman to trial. But they eventually, I think they drove that guy to resign, and then they brought in Angela Corey from the state.
I forget how
judicial district.
How did they manipulate the recusal of that prosecutor? Because I do remember when
I think he just came under so much pressure. There were so many protests that he just quit, and that left the office open. And when the office was simply vacated, they brought in Angela Corey from the Jacksonville area to try the case.
Whom I know well.
You have my sympathies.
Well, actually, she's out of my jurisdiction. We're going to get Jacksonville. I think they're going to realign the districts here. So we're going to get Jacksonville. But I had a friend of mine who came to work for our office that was shell-shocked out of her office. That couldn't, that like was traumatized by working under her. So,
well, it was amazing to watch her. I mean, of course, she didn't actually do anything really per se active in the trial. She was in the courtroom every day, and of course she's the boss, so all the prosecutors there are working for her. They're following her marching orders. But I would see these team of 4 or 5 or 6 prosecutors every day in that case doing the most outrageous things and making the most ridiculous arguments, and I'd be like, how can you even look at yourself in the mirror in the morning doing this? But of course they were all doing it because they work for her, and that's what she told them to do.
Thank God for Mark O'Mara. He did a great job. That was one of the best defense attorney performances I think I've ever seen in a public
Don West,
case.
right? Mark and Don
West did a great job on that case.
Let's see. Peter, $10 super chat, writes, Andrew, I'm in Wisconsin. What is the closest firearms trainer you would recommend that you would call world class? I always feel guilty about this because I've been hosted by firearms trainers all over the country, and I'm sure a lot of them are great, but I've never taken instruction from them personally, so I wouldn't know really. So unless there's about 10 or 12 instructors that I do recommend personally because I know them, but it's not, I don't keep a Rolodex of instructors around the country to recommend, folks. If you didn't know any place else to go, probably a great place to start would be the SIG Arms Academy up in New Hampshire. If you can get there, they're a very large organization. They have lots of excellent instructors. You can't really go wrong. But even then, I wouldn't be recommending any individual instructor by name. It's just a good organization. Let's see. And looks like the last one, Pope Rackets touched me again, this time a $10 super chat. Thank you, sir. That made my day. I guess that I said his name the first time. Any news on that cop that shot the guy in the wheelchair in Arizona? Can't believe there was no charge with that last shot being lagged.
Yeah, I remember that case. What did happen with that?
I don't know. I don't know what the resolution was there. I did write about it at the time.
Should follow up on that. Hey, shout out, by the way, your chat guide, Shane Seuss he's really something. He does a good job on your chat.
He does. He's very busy. Hardworking guy there.
Hardworking guy. I know you pay him well.
Yeah. So, all right, folks, I'm going to start to wrap up. I'll be doing a show on the Indianapolis mall shooter, as I mentioned, probably tomorrow morning. I have something else scheduled in the afternoon. We have a great show for tomorrow afternoon. I haven't promoted it yet. It is pending on the YouTube channel. We have Don Kilmer, who's an expert lawyer on Second Amendment issues. I'll be interviewing him tomorrow afternoon about the Bruin decision. So very happy about that. And maybe in the morning, I'll do a short show on the Indianapolis mall shooter, really talking more about defense of others generally than the specific facts of the case, because obviously he's not facing any charges, thankfully, in that particular case. And I think that's about it for me. Kurt, you have anything coming up you want to plug? Is Kurt on? Did he mute us?
I don't know. Well, he's on uncivil law.
Uncivil law. All right. Well, you know where to find Kurt. I guess he just wants. Did he fall asleep? Sometimes he does that.
I don't know, but well.
All right, Steve. And
He was
Steve is-
enthralled.
I'm still waiting for Steve to write a book or something, so we have something.
I've been writing articles, though I don't make any money off them.
Okay, well, you got to start monetizing, my friend. Hopefully, many of you know that I am planning to start a series of law school like courses. I'm hoping to have Steve teach one of those starting this fall. We're still working, pulling together a faculty to teach a bunch of those courses, but I hope to have news on that within the next week or so for Steve as well as everybody else. And hopefully we can make that a go. We have a lot of interest in it, so I'm really excited about that. And other than that, I think that's it for the day. Oh, I am talking with Nick Wakeda about me riding out my motorcycle out there, shipping them a case of books. Thomas Binger is still listed as an assistant DA in Kenosha County, and we're planning to bring him a case of my law of self-defense books for his office and hand deliver them in person, hopefully live stream that.
Oh, that would be, you videotape that. That would be hilarious.
Absolutely, we'll do that. And
it sounds like fun.
I just have to coordinate with Nick. I'm shooting for like the 3rd week of August to be out there in Kenosha County for that delivery, but we'll see what happens.
Hey, well, so thank you for the invite, and it's always fun to come on with you. I just had a little window here that I could come on, and I appreciate you everything you do. Thank you very much.
I've got to be more proactive about kind of sending out notices to my little legal community, just in case people have a window of opportunity to jump in. I'm not very good about that, but I'll try to get better. All right, folks. Steve, Kurt, I'll say goodbye for now. I'll sign you guys out, and then I'll do my little goodbye for the whole show. Thank you guys so much for coming in and contributing. I can't tell you how much I appreciate it. And for everybody else, remember, if you carry a gun, like I carry a gun, if you carry a gun so you're hard to kill, so your family is hard to kill, then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict as well. And you can find out more about that at lawofselfdefense.com. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.